everyone, my name is Jericho S. Hermoso, a criminology intern at the State University of Northern Negros. Today, I'll be discussing a very important topic in the field of criminal procedure, Rule 170 of the Rules of Court, which focuses on the motion to quash. This rule plays a crucial role in protecting the constitutional rights of the accused by ensuring that no person shall be placed on trial without proper legal basis. It is a safeguard against wrongful prosecution and ensures that every case brought before the court stands on valid and just grounds. As a future law enforcers, public servants, and justice advocates, understanding this rule is essential because upholding due process isn't just a legal requirement. It is a commitment to fairness, accountability, and the rule of law. So join me as we unpack each section of Rule 170, understand its purpose, application, and examples, and see how it works in real legal practice. At the end of this discussion, I hope you'll gain not just knowledge, but a deeper appreciation of how our justice system protects both the rights of the accused and the integrity of the law. Let's begin. Did you know that before a trial even begins, the accused has the power to challenge the case itself? This is through what we call a motion to quash. It's not just about escaping justice. It's about making sure that case stands on solid legal ground. Section 1. Time to move to quash. At any time before entering a plea, the accused may file a motion to quash. Think of this as hitting the pause button on a criminal case. Because once a plea is entered, this right is generally lost. Timing is everything here. Section 2. Form and contents. The motion must be in writing, signed by the accused or their lawyer, and must clearly state the factual and legal grounds. The court can only consider the reasons you wrote, except if it involves lack of jurisdiction, which the court can consider at any time. This ensures clarity, precision, and fairness. Section 3. Grounds for a motion to quash. This is the core of Rule 170. These are the valid legal reasons why a criminal case can be challenged. A. That the facts charged do not constitute an offense. For example, the information alleged that someone looked angrily at another person, that is not a crime. B. That the court trying the case has no jurisdiction over the offense charged. Example, a murder case filed in municipal trial court, which only has jurisdiction over minor offenses. It is improper. C. That the court trying the case has no jurisdiction over the person of the accused. Example, the accused was never arrested, subpoena, or voluntarily appeared. The court has no authority over them yet. D. That the officer who filed the information had no authority to do so. For example, a barangay tanod files the information instead of the prosecutor. That's invalid. E. That it does not conform substantially to the prescribed form. Example, the information fails to state the date, place, or essential facts of the crime. F. That more than one offense is charged except when a single punishment for various offenses is prescribed by law. Example, charging someone with theft and estafa in one single information. G. That the criminal action or liability has been extinguished. Example, the accused already died or the penalty has already prescribed. H. That it contains averments, which is true would constitute a legal excuse or justification. Example, the information itself states that the act was done in self-defense. And I, that the accused has been previously convicted or acquitted of the offense charged, or the case against him was dismissed or otherwise terminated without his express consent. Example, if someone was already acquitted of theft, they cannot be charged again for the same incident. That's double jeopardy. Section 4. Amendment of the complaint or information. If the defect in the information can be corrected, for example, a missing detail, the court shall order the prosecution to amend it. But if the error cannot be corrected or remains defective, the motion to quash will be granted. For example, if the date of the offense was missing but can be inserted, the prosecution can fix it. But if the alleged facts do not amount to a crime at all, no amendment can save the case. Section 5. Effect of sustaining the motion to quash. When the motion to quash is granted, the court may allow the filing of a new complaint or information. If no new case is filed within allowed time, the accused must be released unless they are detained for another case. For example, if Pedro's case is quashed due to a technical error, the prosecutor may file a corrected case. But if the prosecutor fails to do so in time, Pedro must be set free. Section 6. Order sustaining the motion to quash, not a bar to another prosecution. Exception. A quashal does not prevent another case for the same offense, except when the motion is based on extinguishment of liability or double jeopardy. Example, if the case was quashed because of clerical error, the prosecution can refile it. But if the case was quashed because the accused was already acquitted, the prosecution cannot file it again. Section 7. Former conviction or acquittal or double jeopardy. Once an accused is convicted, acquitted, or the case is dismissed without their consent, the state cannot try them again for the same offense. However, there are 3 exceptions when a graver charge can still be filed. First, when new facts develop after the first case. Second, when the facts constituting a graver offense were discovered after the plea. Third, when a plea to a lesser offense was made without the consent of the prosecutor and the offended party. For example, if Anna was convicted of slight physical injuries but the victim dies later because of the same act, she can be charged again for homicide. That's supervening fact. Section 8. Provisional dismissal. A case may be provisionally dismissed only with the accused express consent and notice to the offended party, if not revived within 1 year for offenses punishable by 6 years imprisonment or 2 years for offenses punishable by 6 years, the dismissal becomes permanent. For example, if the case for slight physical injuries is provisionally dismissed and not revived within 1 year, the prosecution loses the right to file. Section 9. Waiver of grounds. If the accused does not file a motion to quash or fails to allege a specific ground before entering a plea, certain objections are considered waived, like lack of jurisdiction or double jeopardy. For example, if Mark pleads not guilty and later complains that the court has no jurisdiction, it's too late. He already waived that objection. The motion to quash is more than a legal strategy. It is a protection of rights. It ensures that no one faces trial without due process, valid jurisdictions, and a proper legal basis. In every criminal proceeding, justice is not just about punishing the guilty, but also about protecting the innocent and upholding the rule of law.